So I want to talk about there's a lot of testimony with the Karen Reid case right now that constantly all these different witnesses, and there seem to be something every day that something new is revealed or it's, breaking news. But one of the things that I feel like is overlooked in the main news, but on YouTube has kind of gotten a little bit of attention, is testimony from Alli McCabe. Allie is the daughter of Jen McCabe, who everybody knows which witness that is. But I wanted to show y'all a clip today, if you haven't seen it already, of this is a snippet from her testimony where she makes an admission that is sort of, to me, I was like, whoa. I was like, okay, done. Like, what are we doing here? Because the big argument has been whether or not John O'Keefe was in the house of the yard he was found in front of.
Right.
And so what she's talking about, you'll hear her talk about it. I don't know if it leads into this with the clip we're going to show, but that particular night she had picked up Colin Albert and taken him home from this party. And so that's where they're questioning her about her travels that evening. Yeah. So
basically harassment.
Harassment by who?
Bloggers, people online.
And what, if anything, in relation to Colin Albert being in the house has occurred as far as the harassment that you're talking about?
Can you rephrase?
With reference to what you were talking about as far as the relevancy of Colin Albert being in the house at that time, what, if any, harassment was there in relation to that and in relation to Colin?
Well,
no, go ahead. She can answer.
Colin wasn't at the house, so he's being harassed he was not at the house when John was there, so I drove him home. So the people are harassing him saying he was at the house when it's not true.
Colin was not in the house when John was there.
What specifically type of harassment are we
Constant phone calls, emails, awful messages.
Objection.
I'll allow it. Focus on this witness, not Colin Albert at this point.
As far as you and your family, what, if any, type of harassment have you received?
People showing up at our house, people emailing my school, just like a lot of harassment. Can I have a moment, please?
Sure.
And that concludes Alli McCabe's testimony. Colin was not in the house when John was there.
Okay.
I'm with you. Shawn, I'm with you.
The question that was asked was, focusing on Colin in the house.
yeah.
Her response does not say Colin wasn't in the house when John was in the house. She's just saying whatever this harassment is of witnesses and the Albert family shouldn't relate to Colin, because Colin wasn't there when John was at there.
At the house.
He didn't say anything. She didn't.
Even if she said in the house, she's not testifying to what happened. She's saying I wouldn't know because he wasn't even there when John was either in the house or outside of the house or anything. We don't know any.
So what you're seeing right now is what you would hear inside the deliberation room with a bunch of jurors. And there will be 3 people that took notes that said, I heard her say he wasn't there when
John was in the house.
When John was there, right? And then there's just going to be this whole conversation then about, oh my goodness, she admitted that John was in the house, and then she had a meltdown when she realized what she had done. Yeah. So was it the her remembering all the harassment that she had, whatever, or has this wall wall that's occurred where they say no, he never came in the house? She realized that she was the first person that admitted that when John was there.
And then there's going to be 3 to 4 or 6 other jurors like me that say, that ain't what she said.
Yeah.
This is what she said.
Even if it is what she said, that's not the topic she was on. I mean, I think that
this is how you get hung juries.
Absolutely. But, it's one of those things that you kind of, as an attorney trying to go back to how we view things, this is the danger of, and I'm not saying that this happened here, but This situation is the danger that we always have when we get the answer we want.
Mm-hmm.
And when attorneys get the answers that you want,
You
it means
sit down.
You sit down. And this is the reason why. Even if somebody's saying something innocently and saying something that they're believing, and that it can be construed differently. So if you already have your answer, witness, you're done.
Yeah.
Sit down. Because
Yeah.
the only thing that can happen is
They'll backtrack. They'll absolutely. They'll get
Right.
squirrely once they realize their last statement, was not
how they meant it.
how
or
they
whatever.
meant it,
Yeah.
or absolutely.
Right, and the defense, I think we'll commend them for having some restraint here in
Yep.
that they didn't follow back up and ask her about it when John was at the house and stuff like that, because then that gives her opportunity to explain away all that stuff, where she's already said the damaging thing.
Yeah.
She's already put it out there, and if you give her opportunity to fix it, then she'll fix it.
Yeah.
Right. And by just leaving it there, it allows for that statement when John was at the house to stay on the notepads of every single juror that meant something to.
And you're
Well,
right
so-
on that, Chase. So generally, you have a notepad like that, and you write down little things.
Mhm.
I do it in depositions. I know y'all do too.
Mhm.
And then if they clear it up, you just strike
It out.
and
Yep.
it doesn't matter anymore.
Yeah.
And that's a very good point. Is the defense attorneys there knew? Okay,
Mhm.
well it's something out there.
Yeah.
It's not our job to clean that up. Let's just
Yeah,
sit down.
let it down.
Let's just let it go.
Yeah.
Well, you make
Yeah.
a good point. That's why I got so excited about it.
Well,
Somebody cleaned it
Yeah.
up.
Well, and
Cleaned it
think
up.
about this.
I was like, wait a minute.
Why?
There's multiple. You don't just necessarily get one
Mm,
time to question a witness.
mhm.
Yeah.
A party calls a witness. The other side gets to cross-examine that witness. Then the party that called the witness gets to redirect if
yeah.
they wish to.
They want to, yeah.
And then you can recross. I mean, it's basically up to the court to how long that could happen. But then if you forgot something, you could call them again later, or the defense could call her as a witness later if they wanted to bring something up. But if you were to get, let's say, for instance, on direct examination, she's a prosecution witness, she would have made the statement, Colin wasn't there when John was in the house. If the defense was smart, they would have left that alone if it wasn't cleared up, because it's more impactful to be able to argue later at closing and even to show them the transcript, because a lot of times you can ask the court reporter, I need a transcript of just this portion right here. Alli McCabe said that John wasn't or that Colin wasn't there when John was in the house. But if you were to cross-examine her on that question, she's either going to explain it, or even if she says the same thing, then you have redirect examination by the prosecution where they're going to ask her several questions that are going to lead her in the path to explaining, oh, well, no, that's not what I meant. I just meant Colin wasn't there during this time frame when John was supposed to be at the house or dropped off at the house type thing. So there's
and this is why attorneys get so crazy about how you word things.
Mhm.
You all think we're crazy.
Words matter.
But it may take us an hour to read a single page from a transcript because we have to dissect every word. And it's reasons like this. If you don't, your case is tanked. It's tanked. And if you don't fix these things, that's a problem.
Yeah.
So no need to turn a mountain into a
molehill.
But that's a meltdown into a.
So essentially, we're as attorneys sitting at the table, we're having to try to do this very fast and going, should I object? Should I cross? Is it worth it? If I do this, is it going to be more harmful than good? And you're not always right. You have to make the call and you got to make it quick.
So in this case, what do you think the defense, that was the right call to make us to not
I do.
leave it
sure,
alone?
absolutely.
Leave it alone.
And I think the
Leave that
prosecution
out
should have
there.
cleaned it up. But the thing is, the girl's nervous. The prosecution's nervous too. They're not thinking about that. They're already thinking about the next question and where they need to go. And they got it, like we talked about earlier, direct versus cross.
Right.
You can't just say things.
Yeah.
You got to lead them into it without leading them. So that's where your brain is. And so I guarantee you the defense heard that.
Yeah,
The prosecution probably didn't.
Yeah. And the prosecution probably didn't, because they would have come up with Well, you said John was at the house.
Right.
Was John ever in the house?
Yep.
But here's the thing about that is that he better know the answer to that damn question.
You're right.
Mhm.
That's a very good point, Chace. That's a very good
He
point.
better know that, and that may be
and
why.
he may have said, "I don't know the answer."
Right. So I'm not
Leave it
asking.
alone.
Yep.
Yeah. So
If
So-
as an attorney,
because
that's
it can
another
be
rule.
interpreted the way Shawn interpreted it and the way I interpret it totally different. So he probably left it alone
That's
because he's
solid
like, I
point.
don't know.
But
I don't know what she's gonna
The
say
rule
here.
is, if you don't, as an attorney, if you don't know the answer that you're about to get back, then you don't ask the question. And so you don't just go into court and just go, "Well, I hope they say yes." I mean, that's how you die. That's rough.
Yeah.
For more courtroom hot takes and breakdowns from the Karen Reid trial, make sure you follow our channel. Stay plugged in.